That is 5 to 5,000. I have considered another matter in my client's home will be demolished. 5,000, 5,000. And without prejudice, let the application. Oh, sorry. Yes, yes. Let the application be heard out any day, and I will start paying from this day. But it is without prejudice, and we are not admitting the content of the application. It will be heard on merit. But since this application, but without prejudice to the rights and contention.
My lord, only two things. My lord, only two things, my lord. My lord, we had made a request, my lord, that if it can be 7,000, and the rest was, my lord, whatever your lordship shall find it fit and proper without prejudice. My lord, we are also on without prejudice. Now, my learned friend is there. He says that it is with respect from now onwards, this month and thereafter. He is going to pay an ad hoc, and that is the reason why he said that I'm going to take instruction and come back. And he came initially with 5, my lord. It was as per instruction, my lord, it was 7, which I beseeched your lordship, my lord, may kindly, if they can pay 7,000. However, my lord, what I am on is a very limited score. Our application was 2/4. Our application was in 1994 August, my lord, was the last receipt which we have received. My lord, even if we just try to perceive the situation, there's an appeal which is pending before your lordship, which is required to be heard out on merit. My lord, the end result of the appeal is either they will stay or they will go. But the fact remains from 1994 till date, my lord, they are using it. They are occupying, enjoying and using it. So it is at this period, my lord, it also, my lord, I felt that it would be reasonable that if your lordship adjudicates on that at the time of hearing of the appeal also. So with respect to this 5,500, my lord, what I was beseech, I will reiterate, my lord, 7,000. The rest I leave it to your lordship.
Kindly do not dispose of this application for the simple reason the application is seeking for an entitlement to get occupational charges. If your lordship says, my lord, that it's a court order 5,500, and if your lordship says no, that is not, because I do not admit, my lord, her entitlement regarding the occupational charges for two reasons. Because I have not yet started the argument, but I still, my lord, persuaded my client that don't do this, give it. They said ultimately, my lord, that 5,500 maximum elasticity. Then, my lord, without going into the merits of the application, my lord, that kindly direct my client to pay without prejudice.
My lord.
Can we dispose of the applications, I think applications, with an amount of rupees 6,000?
এদিকে আসুন না, আপনাকে বোঝাচ্ছি। জজ সাহেব বলছেন যে এটাকে ওরা 7 বলেছে, আমরা 5.5 বলেছি, আরো 500 বাড়িয়ে দিতে পারবো। হ্যাঁ, তার অন্য ভাইরা বলবে না, তো আমি হ্যাঁ বলে দিচ্ছি। Yes.
And the applications will be disposed of.
But we have kindly record that we have not we have not admitted with regard to the entitlement of their occupational charges. Otherwise, we not.
How can it be disposed?
Then we not kindly interim arrangement.
My lord, let it be an interim arrangement, my lord. My lord, I was
pending the applications. I'll hear out the appeal.
My lord, the thing is, my lord,
at the time of hearing,
my lord, the only thing is that
will show that this can one
no, as an interim measure, my lord, your lordship is passing a direction subject to final hearing. Kindly do it, because they are not in neither, my lord, they said, my lord, that this is
what will be at the time of
suppose, my lord, I succeed.
At the time of passing of the judgment, what will be there?
Judgment means the final judgment.
Yes, final judgment. It will reflect that essay, this number of this year, along with can one.
No. This application will be heard after vacation, 2 weeks after vacation.
My lord, may
I tell you, lordship.
My lord, may I
say their demand is 20.
Where we are standing today, the fact remains, my lord, that they are enjoying the premises. And my lord, what I was
So-
basically was that at least this
Then, my lord,
process-
all right, well, I understand. My lord, kindly
is
sees,
in-
kindly then records that we said that they are not entitled to this, but your lordship disposed of by saying, directing us to pay 6,000.
And my
I
lord, the
said it is a
pending
belated
case will be
application.
adjudicated by your lordship, my lord, whatever is. This is without
My lord,
prejudice,
my
my
lord,
lord.
because I said they are not entitled.
The intention of the court is to settle that matter as regards to occupational charges at rupees 6,000 per month, payable according to English calendar month.
That is from today. And what about the pending areas, my lord?
Then the application must be in, because it is interim.
This is
This
there.
interim.
In that event, my lord,
Otherwise,
That event, learned
we have to
counsels,
waive out.
learned counsels, then again, both the applications will have to be taken up
they
for
take a
hearing.
hearing. They take it up.
My lord, let us do something, my lord, subject to your lordship's,
But I have one matter, my lord, it will be, my lord,
my lord,
kindly
subject
what-
to your
what-
lordship's decision, my lord.
The-
My lord,
This
he
hearing,
cannot run away.
No, no.
prior to the vacation, this is the last hearing.
Last hearing,
But
my lord.
After he, on the date of hearing, my lord, on the date of reopening,
My
kindly.
lord, let him start paying. And my lord,
But
let
keep
us
it
come back.
pending.
My lord,
it
because
pending.
with respect to the back payment, the areas which has already fallen due,
The
that
final
has to
merit
be
of
decided
that
by your
final,
lordship.
my lord, final merit of the application will be decided
Or
after.
else, my lord, it will be like, my lord, they are occupying the premises since 1994 till 2024, my lord, they occupy the premises without any.
Yes, that is what.
That is what they want to do.
That is what she wants to submit and she wants to pursue. That is her client
My lord,
interest.
two ways. Either I win or I fail. My lord, either way, if I win,
According
they
to
will
my
be
notion, the
evicted
appeal
from
court
the
order,
premises.
appeal court's order disentitles them.
It is fact that both the parties won't win.
Absolutely,
Neither of the
my-
party will win.
my lord. My lord, if it either they are evicted or my lord, they are not evicted. This is the scenario. If I win, they will be evicted. If I don't, my lord, I succeed, they will stay. My lord, then the pertinent question is, my lord, they stay, but they are already staying without paying. So this is the reason, my lord, we came up for that application for
No, mean
occupation.
profit has been discarded by the appeal court and she is trying. She is indirectly trying. What
My
she
lord, I
took
am not praying for mean
No,
profit.
I will. That is what she's indirectly praying. What was
Let
rejected?
us have the interim order and let us come back after vacation.
Interim
Because
order
if
does
any-
not decide the final issue. Kindly pass an
without
interim
prejudice.
without prejudice, and the final matter will be hard final. Matter ends.
The matter ends for you, but the matter does not end for us. At this end, it is still alive. Both the applications are
Today,
still alive.
Millard, today, rightly or wrongly, Millard, at one part we have come to a consensus. The other part we could not decide the issue after vacation. For the last, from 2007 to 24, 17 years have passed. They did not get the amount. I said 5,000 initially. Then I 5,500. I called my client. I 6,000. So my intention is not bad. That since the matter is pending, I will exploit. I said, Millard, on merit in law, I have a right to address your lordship. Your lordship will take a final view. So Millard, kindly do it. Today, Millard, kindly pass an interim order that my client is present on instruction, but without admitting their right.
So learned counsels on consensus, interim order is being passed.
Not on non-consciousness. Millard,
My lord, without prejudice, let that be an order of the court.
without prejudice.
And my lord, with respect to the final hearing of the application, we come back after.
Yes.
vacation.
So the final order is that let both the applications be heard
Yes.
just after the summer vacation.
My lord,
No interim order.
my lord, we had,
No.
my lord, they do not want to pay, my lord.
No, no. But
My lord, because they
But
don't
the-
want to record the consent.
but the applications will be disposed of within the month of June. Applications will be disposed of.
My
within
lord,
the month-
I was beseeching, my lord, we are suffering. We are suffering, my lord. Let them pay and let us come back for the final hearing after the reopening, my lord.
I tell your lordship, my client will say that Millard, I have some legal points to argue. But even then, Millard, all the time when legal points will not make the issue alive, I say, Millard, let them pay. 5,500 for your lordship says 6,000, between 5 and 7. Even then they are telling, I said, decide the issue that whether they're entitled to get the area, whether the amount is entitled. When the court granted leave, appeal court, they file a suit for main profit. They did not do so.
How much you are paying at this present moment?
Millard, rent control 104 rupees. 5 rupees. I said, your lordship says 6,000, 6,000. Interim order, if it is there, final issue.
Well, let it be an interim order, my lord. We are beseeching your lordship. My lord,
But-
6,000.
But interim order, that too, not on consensus.
No.
That is the problem. So let the matter be heard out
Yes, yes.
after vacation.
Yes, deeply obliged. I have one matter, Nilanjan.
Consent record করবে?
আমি করতে পারবো না। আমি করতে পারবো না কারণ দুই ভাই আছে আর
My lord, we are agreeable without prejudice to our rights and contention.
agreeable হলে তো হয় না। Let it be a court order, interim.
That is what I am beseeching.
Then the matter will have to be heard out
I hear it out after vacation.
after vacation.
My
will
lord,
be heard out.
interim stage, let them pay, my lord.
It will be disposed of within the month of June.
Yes, yes, yes.
It will be disposed of within the month of June.
Yes, yes. Month of
No,
June.
no, my lord is saying that with respect to 6,000, my lord, may I just have a talk with him? My lord is saying with respect to 6,000 will be paid every month, and my lord is proceeding to dispose of. Or else, my lord will record that with consent of parties, 6,000 as an interim measure is being paid. The rest will be decided after your. Are you agreeable to that? My lord, let it be recorded.
But from the end of the appellant,
No, but I cannot consent. I will, Millard.
then let the applications, both the applications be heard out.
My lord,
after
they have agreed to 6,000
yes, I
without
agree.
prejudice.
Without
My lord,
prejudice,
I
kindly.
request without prejudice.
Without prejudice.
That is what I am praying. Let it be the final merit whether we are entitled
Your
to the
lordship
area
wants
or not.
that the application should be removed from the file, disposal. This application, two applications. Appeal will be heard later on, but these applications
My
must.
lord, in that event, my lord, only thing, my lord, with respect to the area, my lord, that is to be decided at the time of hearing of the appeal. My lord, let that be the order.
But the application says that
And in the meantime, let
it
this
is
be
disposed of the appeal, because I said that they are not entitled. That is why I said that without prejudice, your lordship.
councils. After all, both the applications remain. That is fact. As regards to the question of area, both the applications remain.
Area and stay, my lord. One is stay, theirs is stay, and ours is area.
As regards to proceedings, any proceedings in
অ্যাপিলটা থাক বেঁচে থাকবে সেটা উঠে যাবে, এটাই তো বক্তব্য তোমার।
No, my lord, what I am on is that, my lord, let this both application be disposed of as long as they are paying within
Both
time
the- both
till
the
the
appli-
disposal of the appeal.
So
And
both
my
the-
lord, with respect to
both
the
the
area amount, that will be heard out at the
On the
time,
date of reopening.
at the time of hearing of
On
the
the
main
day of
appeal.
reopening, finally disposed.
That issue will be dealt with.
Millard,
So
suppose,
that can
no,
be
I
done,
just
my
a
lord.
minute. Millard, I have to pay between 1 to 7 English calendar month.
yes,
All right. 10th is the day. Suppose your lordship decides the issue on 10th finally. I have to pay on 11th.
Senate Council, it cannot be decided on 10th, as because a bench has released the matter on this issue only. As because these two applications became prime than the disposal of the
Rather, my lord, these two applications are the one which has been assigned to your lordship, not the appeal. Just these two applications. That is also, we have to
Let,
get the things.
then both the applications will be taken up after summer
deeply
vacation.
obliged. Deeply obliged. May I deeply obliged.
Both the applications will be taken up after summer vacation. Then as
Adjournment দিচ্ছেন।
let the
উনি application টি dispose
আবার again and again and coming and
let the কোড কি
ওইটা রেকর্ড করুন।
ওটা চেঞ্জ করুন, ডেকে দিন ওটা, ডেকে দিন। Let the matter appear on 11th of June under the heading application.
এটা তো adjournment
না, adjournment হবে না।
Let the matter appear on 11th of June under the heading application are present. So both the applications will be taken up. 11th of June under the heading application.
11th of June.
11th of June.
Much obliged.
ওদের কাছে আছে তো এটা
Will it be my lord's pleasure to take up the Passover matter item
But,
56?
one matter was being heard.
I'm sorry.
One matter about কত itemটা? 62. Mr. Chaturvedi, after that one,
I'm
matter
waiting.
will be
I'm
taken.
waiting.
Well,
Lord, Mr. Bhattacharya is engaged in courtroom number 15. May I just place from where he left, my lord? May I just place the judgment, my lord?
Mr. Chaturvedi, entire day will be required by you, no? The entire day, remaining part of the day. So, this matter will
Yes, my lord.
taken up
Let him place the judgment.
Or else, we lordship may
Tomorrow,
place after
tomorrow.
vacation. No,
After
after
vacation.
vacation. my lord. Tomorrow it can't be.
But tomorrow, what will the court will do?
Tomorrow they are.
Then 12, up to 12 PM applications, it may be striked.
Hmm?
Strike.
Hmm?
That may be deleted. Up to 12 applications
No,
to be mentioned
the-
up to 12. That
Throughout the entire day, the court will go through the applications. I'm not
Other
in favor
appeals
of that.
are there,
No, no. This
Other-
court is for disposal of the second appeal and the first petitioner's appeals, not for only for disposal of the applications.
my lord,
Current counsel, let it appear tomorrow, thereafter it will be seen.
my-
Still, hello. কত short hand যাওয়া হয়নি, আচ্ছা।
part heard.
No, no, not part heard.
Heard it. Because my lord,
Hmm?
uh,
If a matter is heard considerably, then it will be under the heading part heard. Learned counsel representing the appellants commences his submission and submits at length but could not conclude. Let the matter appear tomorrow. That is 22nd. Unextended hearing.
2 PM for
Yes.
the 2 PM. কালকেই করছি ঠাকুর লিস্টে কালকে থাকবে তারপরে একটা ভ্যাকেশন অন্য ফিক্স করা
let us come back tomorrow. Then.
Item number 56.
Good.
56. Actually, 56 for me.
Item number 56.
Hmm.
Lord, I appear on behalf of the respondent. Lord, on the last occasion, Lord, I was addressing your lordships, Lord, on the respondent's right to address the court in a second appeal as to the substantial questions of law which have been framed at the time of admission are actually not substantial. I'm sorry.
Yes, Mr. Chaturvedi.
My lord, the questions of law, my lord, which have been substantial questions of law, my lord, which are framed at the time of admission, my lord, they are again open to a scrutiny. My lord, that is, my lord, the ratio of, my lord, one of the ratios, my lord, of Santosh Hazari, my lord, I was relying on AIR 2001 Supreme Court page 965, and my lord, I was at paragraph 12, my lord, when, my lord, the business of the court, my lord, last permitted me to address my lord. Lord, my lord is taking up, my lord, AIR 2001 Supreme Court page 965. I'm at paragraph 12.
Yes, paragraph 12.
My lord. Lord, the phrase substantial question. The phrase substantial question of law as occurring in the amended section 100 is not defined in the code. The word substantial as qualifying question of law means of having substance, essentially real, of sound worth, important, or considerable. It is to be understood as something in contradistinction with technical, of no substance, or consequence, or academic merely. However, it is clear that the legislature has chosen not to qualify the scope of substantial question of law by suffixing the words of general importance, as has been done in many other provisions, such as Section 109 or Article 133 of the Constitution. The substantial question of law on which a second appeal shall be heard need not necessarily be a substantial question of law of general importance. Then, Lord, the judgment, Lord, is there. Now, Lord, kindly, Lord, come, Lord, directly to paragraph 14. A point of law which admits of no two opinions may be a proposition of law, but cannot be a substantial question of law. In to be substantial question of law, it must be debatable, not previously settled by law of the land or a binding precedent, and must have a material bearing on the decisions of the case if answered either way, insofar as the rights of the parties before it are concerned. To be a question of law involving, in the case, there must be first a foundation of it laid in the pleadings, and the question of law should emerge from the substantial finding arrived at the court. Now I pause here for a moment. So much is being said about a deed. Now what is to be construed, Milord, would come in deliberations. A deed in favor of the son. Milord, is there any foundation, Milord, laid? Either, Milord, challenging the cancellation or by way of a counterclaim? The substantial question, Milord, it is said, should emanate from the pleadings, from the issues drawn from the pleadings.
Yes.
An entirely new point raised for the first time before High Court is not a question of law involved in the case. Now, Lord, kindly Let's come to paragraph 15. A perusal of the judgment of the two courts show has been extensively dealt with the oral and documentary evidence adduced by the parties for deciding the issues on which the parties went to trial. It also found that in support of his plea of adverse possession, so and so, the defendant did not produce any documentary evidence, while the oral evidence adduced by the defendant was conflicting in the nature and hence unworthy of reliance. So what was not pleaded was sought to be brought for the first time before the Honorable High Court or Honorable Supreme Court. Supreme Court said no. Before the High Court, the Supreme Court said, no, this could not have been done before the High Court for the first time. Then Lord kindly, Lord come to Lord page 969, Lord, there would be about 8 lines from the top, a line starting with the words, the appellate court has jurisdiction to reverse. My Lord is very kindly good.
Paragraph 15.
Paragraph 15. The
Yes.
appellate court has jurisdiction to reverse or affirm the finding of the trial court. First appeal is a valuable right of parties, and unless restricted by law, the whole case is therein open for rehearing both on questions of law and fact. The judgment of the appellate court must therefore reflect its conscious application of mind and record findings supported by reasons on all the issues arising along with the contentions put forth and pressed by the parties for decision of the appellate court. The task of an appellate court affirming the findings of trial court is an easier one. The appellate court agreeing with the view of the trial court need not restate the effect of evidence or reiterate the reasons given by the trial court. Expression of general agreement with the reason given by the court, decision of which is under appeal, would ordinarily suffice. So the appellate court concurring need not give elaborate reasons. Lord, this Lord has found favors of the Honorable Court. In 2016, year 2016, Supreme Court, page 4653, Lord, paragraph 23 to 30 would be relevant. 23 to 30. The scope, paragraph 23. The scope of section 100, my Lord is very kindly got.
Yes.
The scope of section 100 while deciding the second appeal by the High Court has been subject matter of several decisions of this court and thus remain no more res integra. A reference of the two cases on this question would suffice. Milord Santosh Hajari, Milord, has been relied upon with approval. I did not place a relevant paragraph. Kindly, Milord, come directly to paragraph 24. Uh, 25, which is, Milord, at page 4660. Again, in the case of Thiagarajan, that is 2004, volume 5, SEC 762, the two judges bench of this court in paragraph so and so observed. Subsection 5 of section 100 says that the appeal shall be heard on questions so formulated in the respondent at the hearing of the appeal be allowed to argue that the case does not involve such question of law. I am relying on this. The proviso states that nothing in the subsection shall be deemed to take away or abridge the power of the court to hear for reasons to be recorded the appeal on any other substantial of question of law not formulated by it, if it is satisfied that the case involves such question. In the instant case, the High Court at the time of final hearing formulated 5 questions of law extracted from, this is not relevant. Then Lord, kindly Lord, come to Lord 27. In our considered opinion, the aforementioned questions cannot be regarded as satisfying the test of being a substantial question of law within the meaning of section 100. These questions, in our view, are essentially questions of fact. In any event, the second appeal did not involve any substantial question of law as contemplated under 100, and lastly, no case was made out by the respondent before the High Court for remanding of the case to trial court de novo trial in all the civil cases. Now, kindly, my lord, have a look, my lord, to the questions, my lord, formulated. My lord would find that if today an inquiry is, my lord, proposed with apropos, my lord, the questions so framed by the honorable division bench while admitting the appeal, they would invite, my lord, exactly on these questions of law, which the honorable Supreme Court has said that these are questions of facts, definitely not questions of law. Kindly see, my lord, the second question of so-called question of law in paragraph 26 on the same page. Whether the court below have failed to see that exhibit A2 gift deed being a 30-year-old document, the presumption under section 19 of the applies both with regard to execution and attestation as regards the opinion of the trial court that it is a suspicious document is untenable and unsustainable in law. Then, question number 4, whether the lower appellate court has erred in law in holding A2 gift deed invalid because the property gifted to so and so when the government itself has not disputed either wrong possession or possessory title of the plaintiff of the suit property. Again, the construction was under challenge, concurrently held in favor of one party. The court says that now getting into the text of it and to say whether this construction is correct or not, this is getting into the facts of the document. This is not permissible. But that is 27. The next judgment that I rely is AIR 2019 Supreme Court, page 3024. Paragraph 21, 27, and 28. On this issue, my lord, this is a last judgment. And this clinches the issue, my lord, insofar as, my lord, my right to address, my lord, on there being no substantial question of law involved in the case is concerned.
Yes, Mr. Chaturvedi, which paragraph?
My lord, paragraph 21, 27, and 28. 21 is on 3029.
Yes, 21.
But subsection 1 of section 100 says that the second appeal would be entertained by the High Court only if the High Court is satisfied that the case involves substantial question of law. Subsection 3 makes it obligatory upon the appellant to precisely state in memo of appeal the substantial questions of law involved in the appeal. Subsection 4 provides that where the High Court satisfied in substantial question law is involved in the case, it shall formulate that question. In other words, once the High Court is satisfied after hearing the appellant or his counsel, as his case may be, that the appeal involves a substantial question of law, it has to be formulated that the question and then direct issuance of notice to the respondents of the memorandum of appeal along with the question of law framed by the High Court. Subsection 5 provides that the appeal shall be heard only on the substantial question of law formed by the High Court under subsection 4. In other words, the jurisdiction of High Court to decide the second appeal is confined only to questions framed by the High Court under subsection 4. The respondent, however, at the time of hearing of the appeal is given a right under subsection 5 to raise an objection that the questions framed by the High Court under subsection 4 does not involve in the appeal. The reason for giving this right to the respondent for raising such objection at the time of hearing is because the High Court frames a question at the admission stage, which is prior to issuance of notice of appeal to the respondent. In other words, the question is framed behind the back of the respondent, and therefore subsection 5 enables him to raise such question at the time of hearing. That question framed does not arise in the appeal. The provisor to subsection 5, however, recognizes the power of the High Court. There is no doubt about that. Well, kindly may not come to paragraph 27. It cannot be disputed that subsection 5 gives the respondent a right to know on which substantial question of law the appeal was admitted for final hearing. Subsection 5 enables the respondent to raise an objection at the time of final hearing that the question of law framed at the instance of the appellant does not really arise in this case. Yet the other reason is that the respondents are only required to reply while opposing the second appeal to the question formulated by the High Court under subsection 4 and not beyond that. If the question of law is not framed under section 4, the time of admission or before the final hearing of the appeal, there remains nothing by the respondents to oppose to the second appeal at the time of hearing. In such situation, the High Court will have no jurisdiction to decide the second appeal finally for want of substantial questions of law. So, my lord, and a memorandum, my lord, falls before the court. My lord, substantial questions of law prima facie, my lord, are, my lord, framed, notice issued to the respondent, and then my lord, the right of the respondent accrues to agitate before the court that the substantial questions of law so framed, my lord, they do not arise in the present facts and circumstances of the case. My lord, I address your lordship's note on the two substantial questions of law which have been framed. I address your lordship's note that in the present case, my lord, these two, my lord, questions of law, my lord, do not arise at all in the nature of being substantial in nature. My lord, I would, my lord, take, my lord, to some relevant portions only of the paper book, my lord, before I finally that address your lordships on the decisions that I rely on. Lord, kindly takes the paper book.
Yes.
Lord, kindly come to internal page 4 of the paper book.
Defense plea.
Defense plea. Now, whatever, my lord, has to emanate from here. This is, my lord, the groundwork laid down before the court. The trial court was deciding these issues. There is nothing on record to show that the plea has been wrongly recorded. Consistently, this plea, my lord, has been taken forward by the defendants before the trial court, before the appellate court, and, my lord, has come before this honorable court. The defendant admitted that Kamala Devi is the mother-in-law of the plaintiff and his mother, and also admitted execution of deed in favor of the daughter Lokhi Devi on 8/2/2001. So, my lord, the mother Kamala Devi first executes a deed in favor of her daughter. Then he also admitted that the said Kamala Devi was in physical possession of her daughter's property. Subsequently, due to some reasons, she revoked the deed of settlement by virtue of a registered deed of revocation, which was registered on 26th June 2003 before DSR Howrah, video number so-and-so. After revocation, she further gifted the southern portion of her property in favor of wife of the defendant by a deed number so-and-so. The said Kamala Devi also made a deed of settlement in northern portion in favor of the present defendant by a deed dated so-and-so. So, my lord, the story begins from 2001. But mother settles it in favor of the daughter-in-law and, my lord, the son. How? in favor of the daughter, then revokes it, then settles it. But a plea is taken and judgment is cited that a registered document which conveys a right, title, interest in presente, Milord, cannot be revoked by another registered document. It has to be only by way of a declaration by a competent court of law. If I hold that to be correct, then this, Milord, is an admission that the right which came into the hands of the son was by dint of a cancellation of a registered document which was executed by the mother on a date anterior to when the son got it. Lord, may I come again? Lord, the property was first given to the daughter, then it was cancelled.
In the year 2001.
Yes. Then it was cancelled by another subsequent deed.
In favor of the daughter through deed of settlement. In favor of the daughter.
Yes, yes. 8th February 2001. Then the next line, he also admitted that the said Kamala Devi was in possession of her daughter's property. Subsequently, due to some reason, she revoked the deed of settlement.
The first deed of settlement in the year on 8th of February 2021.
Yes,
In favor of the daughter.
yes. This was cancelled 23rd June 2003.
Cancelled through a deed of revocation.
Yes, 23rd June 2003. Number so and so. And after revocation, she gifted this southern portion of the property. I'm sorry.
Cancelled through a deed of revocation on
23rd June 2003.
23rd June 2003. Thereafter,
But gifted that portion
gifted that portion to
the defendant's wife, that is her daughter-in-law. On 19th September 2003.
19 September 2003. Yes.
And then, my lord, kindly sees the said Kamala Devi also made a deed of settlement in respect of northern portion of the scheduled property in favor of the present defendant by a deed of settlement dated 17/3/2003. This is the deed, my lord, by which the son, the defendant, appellant before my lord, is, my lord, asserting a right. The kindly, my lord, turn over. After, my lord, this is cancelled, this is settled in favor of, kindly see the second line, the defendant has stated that he came to know from the recital of the plaint that Kamala Devi transferred the suit property on so and so by a registered deed of sale in favor of the plaintiff. Now he says that he has come to know from the plaint.
Yes.
But kindly only remember this, my lord, I shall show the relevant portion of his evidence, only, my lord, 2 questions. Then, my lord, the other findings here, my lord, are not relevant insofar as I am concerned. Lord, I take, my lord, to internal page 11. Now the main question. Now the main question to be decided is that whether the document marks Exhibit 8 is in the nature of deed of settlement and is a document in presente. Then it was held in so and so although no straitjacket formula has been evolved for construction of such documents, the consistent view of this court and various high court is that while interpreting an instrument to find out whether it is a testamentary character which will take effect after the lifetime of the executant, or it is an instrument creating a vested interest in present day in favor of a person, the court has to carefully examine the document as a whole, look into the substance thereof, the treatment of the subject by the settler executant, the intention appearing both by the express language employed in the instrument and by necessary implication, and the prohibition, if any. Now, in the instant case, my lord has seen that the document was present, my lord, shown to your lordships. There is no express prohibition which restrains, my lord, the settler to revoke the document. It has also been held that the form or nomenclature of the instrument is not conclusive and the court is required to go into. Then what the court considers. Then we will kindly come to internal page 13.
Yes.
Lord, kindly sees, Lord, the last paragraph. The conditions in the settlement deeds are as follows. Lord, my learned friend, Lord, has placed this, Lord, more than once. Lord, I would not trouble your lordships with it. My lord has understood the intent already. তোমার বসবাসের সুবিধার জন্য আমার খরিদা সম্পত্তির মধ্যে নিম্নের তপশিল বর্ণিত সম্পত্তি তোমাকে অত্র বন্দোবস্ত পত্র দলিল দ্বারা প্রদান করিয়া অদ্বৈ তোমার দখলে দিয়া প্রকাশ করিতেছি যে আমি যতদিন জীবিত থাকিব ততদিন উহার আয় উপসত্ত্ব গ্রহণে ভোগ দখল করিতে পারিব আমার মৃত্যুর পর। This, my lord, qualifies whatever has come until this dadi. Now, a document which says that this will come into effect after my demise from this earthly world, it has to be construed to be a testamentary document. I express my desire, I intend to give you this, I intend to give you this, and this all will be yours. Presently, I am in possession, I will enjoy this, I will take benefits of this, I retain everything with me. And there is no word which says in the entire document that the power to revocation is seized or that this document is irrevocable. So the intent, my lord, will have to be gathered from here. Then, kindly see, my lord, the next paragraph. আমি যতদিন জীবিত থাকিব ততদিন উহার আয় উপসত্ত্ব গ্রহণে ভোগ দখল করিতে পারিব আমার মৃত্যুর পর তুমি বন্দোবস্ত পত্র গ্রহীতা নিবুট সত্ত্বে মালিক হইয়া so and so. That any right, title and interest would transfer in favor of the settlee only after demise of the settler. The settler has also reserved the right of transfer by the settlee, mutation in the name of the settlee, and the payment of taxes. Contrarily, the right of the settlee to transfer, alienate, or mutate the property is again postponed. So I do two things. It's my property. I keep enjoying it. I say that it gets transferred to you and you can seek a transfer only after I die. Second, during my lifetime, you can't transfer. During my lifetime, you can't mutate. During my lifetime, you can't do this. So absolutely nothing but an assurance. But this, my lord, has to be construed to be a testamentary disposition. Then the last three lines, my lord, on page 14. The settler did not divest herself of all the right and title in respect of the suit property while executing the said deed of settlement, that is Exhibit 8. She did not make complete disposition of the property vesting right in favor of the settlee, that is the defendant, with effect from the date of execution. Therefore, no actual right got transferred in favor of the defendant settlee on the date of execution of the document, because she had the right to execute the deed of revocation. This is not very important. If I don't convey anything in present day, and if I retain the right of revocation, in that event, this has to be construed, my lord, to be a testamentary disposition. The testator, the settler had the right to revoke such document according to the deed of revocation being so and so, marked Exhibit 9, executed by the settler, cancelling the deed of settlement is valid. Now, my lord, I pause here for a moment only to say that the validity of the deed of revocation fell for being adjudicated by the trial court only to the limited extent of having its implication on the later deed. If the trial court holds that the deed of revocation is invalid, then nothing gets conveyed to the plaintiff. So the declaration that the plaintiff is seeking, my lord, that could not be granted. To that limited extent only, my lord, the trial court decided the validity or invalidity of the deed of revocation. And at the risk of repetition, my lord, I say that there was, my lord, nothing in the form of a counterclaim filed by the defendant asserting the right, independent right, in respect of the cancellation being invalid and the subsequent deed conveying no title. Then, Lord, kindly sees the next paragraph. This, the evidence part, my lord, which I intended to show to your lordship, my lord, is recorded here. If required, I shall, my lord, show the virgin part of the evidence. On perusal of oral evidence, as led by the defendant, it appears that the DW1 in cross-examination so and so stated that it is a fact that in the year 2007, I got to know that the deed of settlement has been cancelled. Lord, kindly sees this. Lord, defense plea, my lord, when I showed, my lord, I showed to your lordship that he has said that for the first time, upon being served with the plaint, he came to know about the cancellation. In cross-examination, he is saying, I got to know that the deed was of settlement has been cancelled when? In 2007. So, contemporaneously, this was made known to him. It is a fact that Kamala Devi is still alive. And when he came to know about it, his mother was alive, the settler. It is a fact that I have asked Kamala Devi as regards the reason for cancellation of the deed of settlement during the period so-and-so to so-and-so, 2007 to 2015. I have not filed any suit challenging the cancellation of the deed of settlement. So he knew about it. He spoke to his mother about the cancellation. Mother may have given a reason or an explanation, may not have given. But he says he did not challenge it. It is a fact that after receiving summons of the suit, I got to know that Kamala Devi has sold the property on so and so. It is a fact that I have not filed any suit against plaintiff challenging the deed of plaintiff. So he neither challenges his cancellation, nor does he file, my lord, the suit as regards cancellation of the deed in favor of the plaintiff. My lord, the defendant had two remedies. First, challenging his own revocation. Second, when he comes to know about the plaintiff's suit asserting a right by dint of a later deed, he should have, my lord, said that no, this later deed cannot convey any title. I have an anterior dates deed. After that deed is executed, the settler had no right in his favor. How can the property be given to 10 persons successively? That, my lord, has not been done. So he neither challenges his cancellation, nor, my lord, he challenges, my lord, my deed. Admittedly, the defendant never challenged the deed of revocation. Then, my lord, kindly, my lord, turn over the next page, my lord. But admittedly, the defendant never challenged the deed of revocation executed by the settler Kamala Devi or the deed executed by her in the name of the plaintiff. Furthermore, from the oral testimony of the defendant, it is revealed that he had knowledge about the deed of revocation in the year 2007. The plaintiff has produced a letter issued by Kamala Devi. What I read again. The plaintiff has produced a letter issued by Kamala Devi in the name of defendant, which was marked Exhibit 10, and the signature of the said Kamala Devi was marked as Exhibit 10-2, which was identified by her husband PW2. The defendant never took any steps to disprove the same. This is the notice, my lord, which conveyed the revocation. And then, my lord, paragraph 17. Page 17, I'm sorry, page 17, third paragraph. It has already been decided that the executor of the deed of settlement has rightly revoked the same by deed of revocation number so-and-so. It has also been decided that the said deed being number so-and-so for the year was not a document in present day, as such did not confer any right title in favor of interest in favor of the. Then, Lord, kindly will not come to Lord, the learned first appellate courts. Lord, page 39. Well, the points to be considered. Then immediately thereafter, stipulation of deed indicates that the property would vest in the settlee after the death of settler, and settler would continue to hold the property during his lifetime, both of them having the right to enjoy the usufructs of the property. The settlee could not be said to be the absolute owner of the property during the settler's lifetime, and the settler has every right to revoke the same. My lord, the emphasis, my lord, is on the right to revoke. And the conferment being postponed till after the death. Then, my lord, 2005 volume 11, my lord, is relied upon. Then, my lord, kindly come to page 41. Lord, point to be considered. In the cross-examination dated 7/8/15, Lord, this cross-examination of the defendant on 7th August 2015 and 1 Milord of September, Milord, I give the date. These two, Milord, are very important in only in as much as 4 questions, Milord, were put to him. Relevant questions were put to him. Did you have knowledge of the revocation? Answer is yes. Did you file a suit? No. Did you have a knowledge that the mother executed a deed conveying the property in favor of the plaintiff? He said yes. Have you challenged it? He says no. Were your relations with your mother good? No. He first says yes. In cross-examination later he says no. These are only relevant, Milord. If required, I shall show. But then, Milord, consistently, Milord, both the courts have come to this finding. Then, in cross-examination, dated so-and-so, the defendant, DW1, admitted he has every knowledge about the revocation in the year 2007, but till today, no suit or counterclaim is filed from its end to challenge the same. As per the law of limitation, he has to challenge within 3 years of knowledge, or from the date of execution, neither has been done. Adverse presumption could easily be made out. Milord, kindly comes to Milord, page 43. Now this quote, second paragraph. Now this court will have to see and scrutinize the deed of settlement and to find out whether the defendant is the owner of the sued property as per the deed of settlement executed on so-and-so and registered on so-and-so date. On scrutiny of the deed of settlement exhibit 9, I find that the settler Kamala Devi has given to stay possess the property, but the settler will enjoy all usufructs of the suit property, and after the demise of the settler, the appellant defendant will acquire absolute right title so and so property, and the right was given to mutate the same, pay taxes, different government. But it reveals from the evidence that in pleadings in the written statement, also from the exhibit 9, that Kamala Devi revoked the deed of settlement on so and so by executing, registering the deed of revocation. And for the reason of revocation, settlement was elaborately written by that revocation deed of settlement to possess the suit property of defendant was revoked, withdrawn, and seized. Lord, there are two documents which have to be holistically read. One which is creating whatever right the defendant understands that it has created, and another the reason for the cancellation thereof. But the mother painfully narrates, and that revocation is virtually written not in ink but is written in her tears. She painfully writes that after I have conveyed this property, the son and the daughter-in-law are ill-treating the parents, and she is compelled, my lord, to revoke it. My lord, this much, my lord, insofar as, my lord, the facts are concerned, my lord, relevant, my lord, evidence, my lord, which I said, my lord, I intend to show to your lordships. I would be failing in my duty if I don't do so. My lord, kindly take up the evidence, my lord, of the defendant number 1. Lord, 7th August 2015. Lord, of the defendant number 1
DW1.
on 7th August 2015. Further cross-examination of DW1 is resumed today on, that would be the caption.
DW1 is Ranjan Prasad.
My lord.
Is the examination chief, further examination chief,
No, further cross-examination,
the cross examination dated
date 7th August.
Yes, 7th August 2015.
Now, before I place this, kindly recollects the case made out by the defendant that after he was given the property, he made a construction and is possessing the property. That is his case. Lord, kindly, Lord, comes to the last 4 lines, starting with the words, it is a fact that Dokhin Bakshara is under the jurisdiction of HMC. Then, I had not obtained any sanction plan from HMC. What is he talking about that he has raised a pakka construction? Earlier, it was a tiled shed. And then the next line, to cover that up, he says, it is a fact that I obtained permission for making construction from Kamala Devi. To raise a Pakka construction, settler is not the authority. You have to need it. You need a sanction from the competent municipal authority. Then, about my lord would find about 12 lines, my lord, from the top. I am not paying any tax in respect of the suit property. Next page. My lord has got it, my lord. I obtained permission, so and so, I am aware, then it is a fact, not a fact.
12th line from the top.
About 12 line.
Mm,
14. Not 15. Kindly do not go.
Yes, sir. I am not paying any tax in respect of the suit property.
Yes.
Hmm.
So he says he has made construction. Then he says, I have not obtained any plan, and he is not paying any taxes. It's only, my lord, the possessory right in joint with the settler is what emanates from the deed. Nothing more, nothing less. The right to pay tax was reserved by the settler to herself. The right to mutate was deferred until the death. The right to get the mutation deferred until the death. Then, Lord, kindly sees, Lord, about Lord, another 6-7 lines therefrom. It is a fact that in the year 2007,
Hmm.
my lord has very kindly got it, my lord.
It is fact that in the year 2007, I got to know.
Yes,
the deed
it
of
is a
settlement.
fact that in the year 2007, I got to know that the deed of settlement has been cancelled by Kamala Devi. Then it is a fact that Kamala Devi is still alive. It is a fact that I had Kamala Devi as regards reason of cancellation. I have not filed any suit to challenge the cancellation of the deed of settlement.
Hmm.
And then the last one is also important, my lord. It is a fact that I have not filed any suit against the plaintiff challenging the deed of the plaintiff. What remains? If you, despite knowledge that here is a deed which is casting a cloud on your right title and interest, you do not institute a suit, and the right to institute one has become barred by limitation, you did not do so. That means you waived your right. Even when the suit comes, you don't file a counterclaim. On the last occasion, my lord very rightly indicated order to rule 2. Lord, just Lord, one more Lord part of his evidence, which is on 15th September 2015. Further cross-examination. 15th September 2015.
Hmm. Hmm. Yes. Which portion?
Lord, it is a fact that other than this suit, there are 3-4 criminal cases pending in between me and my parents. I pause here for a moment. Does the revocation require any further justification? I put this question to myself. A revocation must be justifiable.
Hmm.
The settler retained the right to revoke. The justification, here comes the justification. Son admits 3-4 criminal case with the parents.
Hmm. Yes.
Then, Lord, about Lord, 12-13 lies from the top. It is a fact that before institution of this instant suit, my lord has very kindly got it, my lord.
No. 12 lines from the top.
From the top. My lord would find the number of criminal case, then I cannot remember. Then it is a fact some criminal cases, let that paragraph end. Then it is a fact that there is no mention of criminal case. Then immediately thereafter, it is a fact that before institution of this instant suit, my parents have been trying to evict me from the suit property. So the deed is revoked, criminal cases pending, parents want you to be evicted, the intent is clear. That justifies the revocation, which you did not challenge. And then, my lord, next page, he again says, I have not filed any suit for cancellation of deed of plaintiff. This is reiterated. 7th August, he has already said this. My lord, I do not intend, my lord, to rely on any further. Certain either here.
So his terms with his mother was not good.
Was not good, that justifies the revocation. And my lord, the mother was conscious. My lord, I would say that the mother in that the most wicked and the most poor in wit a mother be, but she would know the son best, no one else. Hence, she reserved the right to revoke. And the intent of the mother is, my lord, coming out, is being reflected, demonstrated from the actions. Or else criminal cases between parents and son. What type of, my lord, good relations, my lord, are there that there exist criminal relations, and still the mother says that very well, you take all over all my property during my lifetime. My lord, Lord, I rely on some decisions.
As regards to cancellation.
Lord, as regards to cancellations, revocation, and also as regard, my lord, to the construction of a document, going by the content thereof.
First, as regards to revocation and cancellation. Thereafter, as regards to
Yes,
content.
yes. Lord, 2012, Volume 1 CHN,
2012.
Volume 1 CHN, Calcutta 195.
Yes.
The paragraphs would be 25 to 30. দেখো দেখো নালে আমি এটা দিয়ে দেবো Lord, here, Lord, what happened, Lord, was, Lord, in 1964, Lord, a property, Lord, was settled in favor of 2 daughters and a son. Lord, this was, Lord, cancelled in the year 1969, and a new deed. And a new deed, Lord, was executed in favor of the 2 sons. Lord, when, Lord, the settler died in the year 1971, Lord, the 2 sons, Lord, sold it. And in 1983, Lord, this property, Lord, fell for, Lord, a dispute, Lord, with regard to the cancellation. But the facts, Lord, here are almost, Lord, identical in nature insofar as the construction of a document is concerned. Lord, I read it to you, Lord. Lord, I am sorry, possibly my learned junior friend, my Lord, has misplaced it in the bunch of documents. It is here, I shall hand up my copy to my Lord. Lord, I read paragraph 25 to 30. It is now settled, well settled, that construction of document of title under which the claim to property is made is a substantial question of law. As to construction, meaning of the words is a question of fact. I'm sorry.
Citation.
Blood 2012.
CHN.
Yes, CHN.
1 minute. CHN. 2000.
2012, volume 1, CHN Cal 195.
195.
My lord.
No.
My lord is not getting it. But I read it and I hand up my copy to my lord.
I give the SCC online citation. my lord.
Hmm?
SCC online citation of this.
Same. Yes. Equivalent to.
Yes, yes.
Yes. Corresponding to. 1 minute.
2011
1 minute. 1 minute.
SCC online Cal.
Hmm. Yes. 2012.
SCC online Cal
Hmm.
5259.
5259. Chandrika Prasad Pandey versus State of West Bengal.
No. Satyendra Narayan Banerjee.
That's in my SCC my lord too. My citation and the both are
2012.
no 11 my lord. It's 11.
2011.
2012.
না না এটা ঠিক আছে মানে এসসিসি অনলাইনের সাইটেশন এটা 2011 আছে
2011. 1 minute. 2011.
এসসিসি অনলাইন ক্যাল 5259 জাজমেন্টটা ডিসেম্বর 16 2011
Yes. Satyendra Narayan
Yes,
Banerjee
yes.
versus Pubali Banerjee.
Yes, yes.
Hmm.
Lord, kindly come to paragraph 25. Let us hope, my lord, that the paragraph numbers match.
No, it comes. So,
No.
Mr. Chaturvedi,
It is now settled,
you place the citation. I'll later on
my lord.
take up. এই কি বলে এইটা না উঠছে না এই রাইট সাইডটা উঠছে না দেখে নিন yes
It is now settled, well settled, that the construction of document of title under which the claim to property is made is a substantial question of law. As to the construction, meaning of the words is a question of fact. This, my lord, I was submitting. But the effect of words is a substantial question of law. High Court can go into the said question in a second appeal. There are sufficient indications in the deed of cancellation of the earlier settlement deed of 1964, the reason for which the settlers were forced to revoke the earlier deed, as is our case. They stated that the settlement suggested in 1984 did not resolve the dispute between the children and the settlers. On the contrary, it aggravated the dispute. The settlers were living with agonies, and therefore the document was revoked and or cancelled, and the new settlement was made in the year 1969 on the very same date. Milord, a perfect analogy can be drawn, Milord, to our case. In this appeal, I am concerned as to whether the settlers, by executing the deed of 1964, created a vested right in favor of the beneficiaries. In other words, whether the 1964 deed conferred any interest in the property in present day in favor of the beneficiaries. The very important provisions of the deed of 1964 is the provision of beneficiaries from transferring or creating any encumbrance in the properties during the lifetime of the settlers. This is the first thing. Then second, the settlers reserved the right to pay the rates and taxes. The 7th August, he said that he did not pay, Kamala Devi was paying. And impose a prohibition on the beneficiaries from mutating their names. As my lord has seen in our case, she reserved the right of mutating, transfer, paying taxes, and transferring, alienating the property. It was stipulated that only after the death of the settlers, the property would vest, as is our case. So, my lord, this is, my lord, the facts are pari materia. It is true that the settlement is one of the recognized modes of transfer of movable property. Such transfer by way of settlement is legal and valid, but in order to find out the correct intention of the settlers, the deed of settlement has to be read as a whole. The court has to closely examine the document. Sometimes there is absolute vesting and sometimes there is a contingent vesting. The nomenclature of document is not conclusive one. My reading of the document of 1964 is that the disposition was not a disposition in present day. The document did not take effect on the date on which it was executed, but the settler created rights thereunder to take effect after the demise. It was specifically stated in the document that the property would remain with the settlers and the beneficiaries would not be able to mutate their name in relation to the property. It was further specified that the rates and taxes would be paid by the settlers. It was clearly stated in the deed that the property would devolve on the beneficiaries absolutely only on the death of settlers. I cannot accept the contention that by using the deed dated so and so, the settlers made complete disposition of the property, vesting right in favor of the beneficiaries with effect from the date of its execution. Lord, facts, my lord, are here, my lord, are identical. If you Devin, please, Josh. Okay. But I'm so sorry, my lord, these are marked for my convenience.
Learned counsel,
My lord.
need not be provided. Need not be provided, I will have it. 2012, 1 CHN, Calcutta 1953.
Lord, next, my lord, I cite, Lord, 2010, Lord, volume 3 ICC,
Volume 3 ICC.
Lord, Supreme Court, page 490. PK Mohan.
Zero.
If you Devin, please. PK Mohan. Lord, paragraph 13, 15, and 20. 13, 15, 20.
Yes. Having noted.
My lord. Having noted the distinction between vested interest and contingent interest, we shall now consider Exhibit 2 was a settlement deed or a will. Although no straitjacket formula has been evolved for the construction of such document, the consistent view of this court and various high court is that while interpreting an instrument to find out whether it is a testamentary character which will take effect after the lifetime of the executant or it is an instrument creating a vested interest in present day in favor of a person, the court has to very carefully examine the document as a whole, look into the substance thereof, the treatment of the subject by the settler executant, the intention appearing both by expressed language employed in the instrument and by necessary implication, and the prohibition, if any, contained against the revocation thereof. Then, Lord kindly comes to Lord, paragraph 15.
Yes.
Lord, just a second. Lord, kindly come to paragraph 20.
Yes.
Lord, paragraph 20, Lord said, if I make my testament and last will revoke irrevocable, yet I may revoke it, for my act or my words cannot alter the judgment of law to make that irrevocable, which is of its own nature revocable. Lord, a testamentary disposition. I say that this is my last will, and this is irrevocable.
In spite of that, another will
In
is-
spite of that, I am going to die tomorrow. Today, I execute another will. Say that previous one stands revoked. No plea can be taken that. Once the intent is gathered, my lord, from the text of the instrument, that this is a testamentary disposition. And to the contrary, there is nothing in the, even if we say it is a deed of settlement, that there is nothing which seizes the right of the settler from revoking it and confers nothing in present day. By all means, the intent is that the right to revoke was reserved, whether we treat it as a testamentary disposition or not. And if I say that this comes into effect after my death, has to be construed to be a testamentary disposition. My love and affection for my son, you stay with me, you jointly enjoy the usufruct, don't mutate the property, don't sell the property, don't pay taxes, don't alienate. I give less, reserve more to myself. And I don't chop my hands by saying that this is irrevocable. I don't do it because I know my son better. I'm a most wicked mother, but no one else knows my son better than I myself. 3-4 criminal cases are pending. So intent has to be gathered. And here, not only the deed which is creating a right in his favor, but also the deed which revokes, both has to be read together. One written in ink, the other written in tears. It takes a large heart for a mother to say that I'm not satisfied with my son. My lord, kindly, my lord, then paragraph 20 within in quotes, my lord, the same thing is quoted. I need not repeat it to my lord. My lord, next, my lord, I cite AIR 1996 Supreme Court 2260.
year 1996 Supreme Court
2260.
2260.
এটা জজ সাহেব এটা কেন ইয়ে করে দিয়েছিস তোরা? ওটাতে মার্ক করা আছে। There's some markings, but better than the colored ones. Okay.
There's no hindrance, but the only thing was that In the earlier one, you had applied much of your effort in the earlier one. So, Mr. Chaturvedi, the remaining part of the day, 1 hour,
Yes, yes.
Lord councils, the other matters are
Yes.
released.
Keep your line.
Huh? क्या बोल रहे होएगा
উঠছে না অধিকটা উঠছে অধিকটা উঠতে গেলে ডান দিকটা উঠছে না উঠছে না আমি দুদিন ধরে দেখছি দেখে নেবেন
Kindly give me one more. Lord, kindly, my lord, permit me to hold this judgment. I, my lord, I am unable to correlate myself, my lord.
Which
I am
paragraph
missing
is
some
this?
link somewhere. My lord, kindly permit me, my lord, to rely on AIN 1957. Okay. So this is AIN 1957, Supreme Court, page 255.
Yes.
Lord, this is not again on section 19 and 21. I read the head note to your lordship's note. I hand up my copy to my lord. Lord, it's a little embarrassing. The intention of the settler to be gathered from the terms of the trust deed held interest taken in this case was vested and not contingent. Lord, where and how, Milord, it is to be, Milord, understood, it's to be gathered, Milord, from the text of the deed itself. Milord, what has been laid down in 2012 CHN, Milord, remains to be a good law. Remains to be a good law that, Milord, it has to be gathered from the deed itself, Milord, need not look elsewhere. And when I say, Milord, that there has to be a wholesome reading, there has to be a wholesome reading of the one which purports to create a right and which, Milord, takes away that right. Both have to be read in conjunction. Milord, now, Milord, I proceed, Milord, to distinguish, Milord, the judgments, Milord, which my learned friend, Milord, has, Milord, relied.
So, Mr. Chaturvedi, you have cited 2012
My lord,
1 CHN Calcutta 195,
my lord,
2010 3 ICC Supreme Court 490. AIR 1957, Supreme Court 255.
My lord.
Apart from these three,
But the other judgments were on substantial question of law.
okay.
AIR 2001,
Mhm.
2016,
Right.
and 2019. Lord, kindly, Lord, take up 2013 volume 7 Supreme Court cases cited by my learned friend. Lord, I shall very briefly, my lord, deal with them. ठीक है, কোনো অসুবিধা নেই। ঠিক আছে, কোনো অসুবিধা নেই।
2013 7 SCC
My lord,
490.
my lord. Lord, paragraph 15 and 16, my lord, have been relied upon.
Yes.
Lord, construction of a document of title is a question of law. That is the proposition. Lord, kindly come to paragraph 16. We may, however, note in this behalf that as by a constitution bench in Chunilal, it is well settled that the construction of a document of title or of a document which is the foundation of right of parties necessarily raises a question of law. That apart, as a bench of 3 judges in Santosh Hajari, whether a particular question is substantial question of law or not depends on the facts and circumstances of each case. When the execution of will of Nagamani and construction thereof was the subject matter of construction, the framing of question of law cannot be faulted. Lord, I pause here for a moment. Lord, in our case, is the cancellation, Lord, the subject matter? The deed which conveyed title in my favor was the subject matter. To bring the cancellation to be a subject matter, there had to be a counterclaim. Or else, my lord, I am benefited with my lord's observation order to rule 2. There is no prohibition to entertain a second appeal, even on a question of fact, provided the court is satisfied that the findings of the court below were vitiated by non-consideration of relevant evidence or showing erroneous approach to the matter and finding recorded before are perverse. This is not the case build-up. That this has not been considered or the concurrent finding of fact is perverse. It's without any materials on record. Or that a particular evidence which is relevant has not been considered or an irrelevant material has been considered. This is not the case developed before your lordships. My lord, 2010 volume 12 Supreme Court cases, page 740. This is against the appellants. Volume 12.
Mm, It is noted, paragraph 17, 21, and 24.
My lord, my lord.
Record.
Copy है, sir. May I hand up my copy, my junior's copy to my lord in the meantime?
No, Mr. Jadavadi, you only rely upon the facts?
Yes. Lord, paragraph 17, 21, and 24 are relied.
Hmm.
And this is not for the proposition that if the findings are perverse based on no evidence or irrelevant materials in a second appeal, it can be interfered still.
Hmm.
If it can be shown that it is based on no material, irrelevant material, then even concurrent finding of fact can be interfered. No doubt about it. Perversity vitiates. But, my lord, what is more important is the paragraph which has, my lord, not been relied upon by the appellants. They will not operate against him.
Which paragraphs?
My lord, paragraphs 18 to 21.
1 minute. Eighteen to 21.
18 to 21.
Hmm.
Now, in the garb of, my lord, framing a substantial question of law, what cannot be done? In so and so 1998 volume 6 Supreme Court cases, this court held that the question of reappreciation of evidence and framing the substantial question of law as to whether the findings related to the factual matrix by the court below would vitiate due to irrelevant consideration and not under law, being question of fact, cannot be framed.
Yes, yes.
Then, my lord, relying on 2000 volume 6 Supreme Court cases, Rajappa's case, this court held that it is not permissible for the High Court to decide second appeal by reappreciating evidence, as if it was deciding the first appeal, unless it comes to a conclusion that the findings recorded by the court below was perverse. Then, my lord, relying on 2002 Jai Singh's case, my lord, it is permissible to interfere even on questions of fact, but it has to be done only in exceptional circumstances. What are exceptional circumstances are noted. Then 21, Chandrasekharan's case, my lord, 2007 volume 5 Supreme Court cases. This court reiterated the principles that interference in the second appeal is permissible only when the findings are based on misreading of evidence or are so perverse that no person of ordinary prudence could take the said view. Lord, I made this submission before your lordship's lord at the outset, that concurrent finding of fact will only be interfered with only and only when, but if the concurrent findings are not so bad, so perverse, that no man of ordinary prudence can be expected to arrive at such conclusions. So, my lord, this, my lord, is in blood, I would say, this inures to my benefit. 2010 volume 12 Supreme Court cases,
740.
paragraph 18 to 21. Then, my lord, my learned friend, my lord, has relied on 2013 volume 7 Supreme Court cases, page 490.
No, that you have.
Oh, acha, এখান থেকে, oh, sorry, উল্টোটা যেতে হবে.
Thereafter, AIR 1959,
My lord,
Supreme Court, page 24.
yes. Now, my lord, an unreported decision of our High Court,
Hmm.
my lord, in second appeal 117 of 2017. Here, my lord, the issue was as to who among the two wives, my lord, is the legally wedded wife.
Passed by Honorable Justice Harish Tandon.
No, this is the
IP Justice IP Mukherjee.
Achha.
the court held, my lord, grossly inappropriate and insufficient appreciation of fact. Lord, kindly, Lord, comes to page 1,
Yes, page 1,
the last paragraph, the material issue.
the material issue for consideration.
Yes, the material issue for consideration before both the courts below was whether the appellant number 1 and the respondent number 1 were, or any one of them was a legally wedded wife of Bhupal Mondal, or whether neither was. The consequential question which arose was which of the two, appellant number 1 or the respondent, was entitled to receive this benefit. On prima facie examination of the judgment of the courts below, we find that there is grossly insufficient and inadequate appreciation of material evidence by the learned judge. This, in our opinion, raises substantial questions of law. Lord, I pause here for a moment. My Lord has seen, Lord, the judgment of both the courts below. Lord, what is the evidence, my Lord, laid in so far as, my Lord, the deeds are concerned? But the extensive evidence of DW1, Lord, the defendant's son, my Lord, has been considered. There is no, I'm sorry, there is no irregularity shown. There is no irrelevancy shown. There is no misappreciation shown. The courts have considered whatever he has said. He says number of criminal cases to be so, the court has recorded. He says the relations not good, court has recorded. He says that, yes, I was intimated contemporaneously about the cancellation, court has recorded. And these only are the relevant factors. Did you challenge? He says no. What else? And in such facts and circumstances, my Lord, the Honorable Court on page 3, third paragraph, arrives at conclusion on the basis of these documents. On the basis of these documents, both the courts below have come to the finding that the appellant number 1 has not been able to prove that she is a legally married wife of Bhupal. In our opinion, the documents produced by the appellants were neither contemporaneous to the death of Bhupal nor contemporaneous to the date of filing of the suit. They were executed over a long period of time. So, in these facts and circumstances, next page, my Lord would find the court relies, my Lord, on 2016 volume 3 Supreme Court cases. The first appellate court is the last court of determination of fact. Usually determination is final. It is well settled that this determination can be interfered with on second appeal only if it is perverse. A perverse finding of fact gives rise to substantial question of law. And Damodar Lal is relied on. Insofar as, my Lord, I could understand, my Lord, the arguments, my Lord, advanced by my learned friend, there is nothing, my Lord, which he says that there is a perversity of finding, or that there is a misappreciation of evidence. The learned courts below have arrived at have said that this is what the son has said. Kindly see the evidence the son has not said. I say, very well. This is misappreciation of facts. And then, my Lord, Damodar Lal, my Lord, which is referred in this judgment, has also been relied upon. I do not, my Lord, distinguish it separately. These are abstract propositions of law. The question is whether these are relevant. Then, my Lord, 1958 SCC online, SC page 38.
Yes.
AIR 1959.
AIR 1959, Supreme Court 24.
Yes, I'm sorry. The paragraph 11 to 13 was relied upon. The proposition of law, if two constructions are admissible in respect of a document, if two constructions are admissible, then, the one which gives benefit to all the clauses must be given effect. When there is a conflict between two clauses, then the former would prevail. I'm sorry. It's only when there is a conflict between two clauses that the latter would prevail. That is, in paragraph 11. Let us understand, and go back, virtually into the deed. She, my lord, says that I give to you this, I give to you this, and this will come into effect after my death. Till then, no mutation, nothing, that I have said already. This is to be read as a whole. None of this forms a separate clause. To say, my learned friend, my lord,
According to you, these provisions are not in contradictory to each other.
they are not. This wholesome is a clause. I give this to you after my death. Now, if you want to punctuate it by saying, I give to you, full stop, then after my death, in constructing the deed, the construction is such that the sentence can't be 10 conjunctive sentences made without a punctuation. Hence, the punctuations are there. But the intention has to be gathered. And once it is understood that all this is qualified by after Amar Mrityur Por, and nothing being there with regard to my right of revocation being seized, then the construction has to be a wholesome reading. And a wholesome reading says that these are not two separate clauses, but one singular provision. I give this to you after my death. I need not place, my lord, paragraph 11 again. This is, my lord, if one clause is in conflict with the other, only then the former clause would prevail. My lord, 2003 volume 3 Supreme Court cases, page 57. Lord, paragraph 14 to 21 was relied upon. Indicate Lord, paragraph 14 to 21, Lord, to the best of my understanding, Lord, they relate to interpretation of statute.
Not to deeds.
And not to documents. And my lord would say a construction which reduces the statute to a futility has to be avoided. A statute or any enacting provision therein must be so construed to make it effective and operative on the principles expressed in the maximum so and so. Liberal construction should be put to the written instruments so as to uphold them, if not possible to carry it in effect. Then 15, a statute is designed to be workable and interpretation thereof by the court should be to secure the object. Then 16, the courts will have to reject the construction which will defect the plain intention of the legislature. Then 17, if the choice is between two interpretations, the narrower of which would fail to achieve the manifest purpose of the legislation. Then 18, the statute must be read as a whole. So, my lord, this, my lord, is not relevant, my lord, I would say.
As regards to interpretation of statute.
Yes. He is talking about the document as to what is to be understood out of the document. This was cited not for the purpose of interpretation of section 19 and 20 or section 126 of the Transfer of Property Act, which my learned friend relied on. This he not cited for the purpose of interpretation of the documents.
Okay.
So, with regard, apropos, my lord, the documents, my lord, not the law is settled for these, my lord, we need not refer to these judgments which are exclusively confined, my lord. These are good laws insofar as interpretation of statute is concerned. Literal interpretation, golden rules, which rule to apply. My lord, another judgment, my lord, unreported judgment of Honorable Allahabad High Court.
Justice Kesharwani.
Yes. My lord, this again, my lord, this relates to interpretation of statute. Paragraph 21 to 23, my lord, is relied. This, my lord, is relating to interpretation of statutes. My lord has very kindly got it, my lord.
Yes.
A contextual reading is a well-known proposition for interpretation of statute. The first line of paragraph 21.
21.
Internal page 14, the pagination would be on the right side bottom. Paragraph 21 reads, contextual reading is a well-known proposition of interpretation of statute. The clause of a statute should be construed with reference to the context vis-a-vis other provisions. This is interpretation of statute. Then paragraph 22, the above proposition noted principles of law find support in the judgment of the Honorable Balram Kumawat. Then paragraph 23, 1989 for SCC, Honorable Supreme Court held that the schedule appended to the statute is a part of the statute. And this is well known, there is no quarrel with regard to this abstract proposition. If the provision of law and a schedule appended to it and the schedule is inconsistent with the main provision, to that extent the schedule would be rendered redundant, the provision, substantive provision would prevail. I do not know, my lord, how is this relevant here? Lord, my learned friend Lord cited P.K. Mohan Ram. I have also relied on it. 2010, volume 4, Supreme Court cases. The paragraphs which I have relied, my lord, I have placed while I was relying. Now, what is not relevant in his case and that this judgment does not inure any benefit to him, I show it from paragraph 29. So the last 3 lines of paragraph 29.
Yes.
In the concluding portion, the settler made it clear that he will have no right to cancel the settlement deed for any reason whatsoever or to alter the terms thereof. It is in these facts and circumstances where the settler expressed irrevocability of the deed of settlement that the court will not held that a right in present day has been conferred. This is not our case. In our case, this is clearly absent. If this was a part of the document of settlement in favor of the son, I would have been out of court, Lord, at least 10 days ago. This is the distinguishing feature. Lord, my learned friend Lord has relied on 2014 volume 9 Supreme Court cases.
Therein, the settler made it clear that he will have no right to cancel the settlement deed for any reason whatsoever or to alter the terms thereof.
That is 2010.
2010.
Yes. But 2014 volume 9 Supreme Court cases, page 445, for the proposition as to while making a settlement, is it signed to or non to hand over the possession? Supreme Court said no. But paragraph 6 to 13 and then 16 to 20 have been relied on. But only a little part of this, my lord, I draw my lord's kind attention. Kindly come to paragraph 17, 1-7. That brings us to the decision of this court, which have led to this reference. But this, my lord, has gone on a reference, my lord, on the issue as to whether possession, my lord, was signed on, my lord, to be handed over at the time, my lord, of execution of the deed of settlement. In Balakrishnan, the donor executed a gift deed of a specified share of property inherited by her and from her maternal grandfather in favor of her minor son, who was the appellant donee before the court, and her 4-year-old daughter. The property gifted included a school building. The gift deed stipulated that the responsibility to sign in regard to the said school and the right to income would be with the donor during her lifetime and thereafter would be vested in the donee. After the execution of the deed, the donor cancelled the same and made a will bequeathing the property in favor of the daughter, whereupon the appellant donee filed a suit for declaration of his title to the suit on the basis of the gift and further declaration for annulment of the cancellation deed and the will executed by the donor. My lord, kindly see the scope of the suit. My lord, for a moment, my lord, permit me to read, my lord, this once again for my understanding. After the execution of the gift deed, the donor cancelled the same, made a will bequeathing the property in favor of the daughter, whereupon the appellant donee filed a suit for, kindly see, first declaration of title to the suit property on the basis of the gift and a further declaration for annulment of the cancellation deed and the will executed by the donor. So first
There
is a declaration. Second, the annulment was channeled. Third, the simultaneous creation of third-party right was also under challenge. In our case,
therein there was a challenge, but herein there is no challenge.
no challenge. Then the trial court dismissed the suit. My lord, I need not. The trial court dismissed the suit while the first appellate court decreed. The High Court restored the view with the view taken by the trial court and held that when the donor has reserved to herself the right to sign papers with respect to management of the school and the right to take where the school was situated, no property was transferred in the in appeal before this court. The view taken by the High Court was reversed. This was Balakrishnan. So Balakrishnan was a case where declaration, annulment, third-party right created was the subject matter. There, my lord, the Honorable Supreme Court, my lord, said no, the High Court did not do right in reversing it. Then the contrary view, my lord, was already there. That was in Mangal Thakkar's case, my lord, and hence the matter went, my lord, to the Honorable Supreme Court with a reference. Then kindly, my lord, come to paragraph 19. The above decision in, I'm sorry, I missed some here. But paragraph 19, the above decision of Maganlal Thakkar case clearly rests on the fact of that case. If the gift was conditional and there was no acceptance of the donee, it could not operate as a gift. Absolute transfer of ownership in the gifted property in favor of the donee was absent, but as is our case. In that case, which led to the court to hold that the gift was conditional, had become operative only after the death of the donee. The judgment is in that view clearly distinguishable, cannot be read as an authority for the proposition that delivery of possession. May I sum up this, my lord? Two decisions, my lord, were operating. One was Balakrishnan, other was Thakkar's case. In Balakrishnan, my lord, the facts, my lord, were distinguishable. But the issue which fell for consideration on reference before the Honorable Supreme Court here was as to whether once a deed of settlement is executed, whether the possession must go hand in hand simultaneously or it can be deferred. Supreme Court was deciding that. But both Balakrishnan and Thakkar will not fail for consideration. It is paragraph 19, not the ratio of Thakkar which the Honorable Supreme Court notes here, which Milord is of assistance to me. And the rest of it, Milord, is of no assistance to the appellant. As to whether while executing the deed, the possession went or did not go with the son is not an issue at all. Because the annulment, as was the case in Balakrishnan, is not an issue in my case. Because the later third party right being created was under a challenge in Balakrishnan is not in my case. So this does not come to any assistance to the appellant. But paragraph 19, which relies on Maganlal Thakkar and says that there is no absolute conferment of title by dint of the document and the right of revocation is not seized, then in that event it cannot be said that there is something which is conveyed in present day. Lord, 2017 Supreme Court cases, online Hyderabad 23. Lord, certain questions of law, Lord, were framed by the Honorable High Court at the time of admission. Lord, whether Lord these are substantial questions of law or not. Lord, that Lord is Lord the subject. Kindly see Lord paragraph 2. The appellants have filed the present writ of second appeal on the substantial question of law as under. Then these Lord are the questions, and considering this, Lord, the Honorable Court arrives at a conclusion in paragraph 13. The last 4 lines. Once the donor had no right to revoke. This is important. There, the right to revoke was not there. Hence, Lord, the Honorable High Court arrived at a conclusion. He cannot alienate the scheduled property. That is Mohanan also, 2010 also records. Revocation is the right to revocation, paragraph 29. That is important. If that is seized, that means whatever is conveyed, the settler does not want any interference by her own self or a rethought or a revisit over the issue at any later point of her life in this world. The 2013 SCC online Karnataka or AIR.
Yes, AIR 2014 Karnataka.
Yes.
Page 58.
Page 58. Lord, paragraph 16 to 19 Lord have been relied upon. Lord, the Honorable Court Lord says that a deed of settlement, it cannot be annulled by a subsequent deed of annulment. A deed of settlement cannot be annulled by another subsequent registered deed of annulment. The only process known to law is by way of filing a declaratory suit that the earlier deed of settlement is void, illegal, inoperative, not binding, only by those means and not otherwise. Again, my lord, at the risk of repetition, I say that this is a good proposition of law had my deed been, my lord, irrevocable. Then I have chopped my hands at the time of settlement. I, as a settler, I have chopped my hands. I have nothing, nowhere to go but to go to the court. That while executing the deed, these were the extending circumstances. When I executed this deed, I made it irrevocable. But today I think that I'll have to revisit the issue in view of these things. Because this is without consideration. And these are the altered circumstances which has forced me to come back. Hence, whatever the court decides. But to say that a testamentary disposition, registered, unregistered, will not matter. It cannot be revoked. I do not think, Lord, in the present facts and circumstances, Lord, this is applicable to. Lord, kindly looks into, Lord, paragraph 16 to 19, if my Lord so wishes, Lord. But to my understanding, this is, Lord, what? Paragraph 17, I read it to your lordships, can't you do not trouble. Once the settlement deed was executed in favor of her daughter, Lokama lost her right, title, and interest in the scheduled property. On the day she executed cancellation deed, she had no right in the property. Why? Because it was construed to be a conveyance in presente. It was construed to be a document which is transferring the right, title, and interest in the presente. Ours is qualified by after mrityur por. Ours is qualified by no mutation, no payment of taxes, no alienation during my lifetime, and also qualified by the fact that I have not put a self-imposed restriction of saying that this is irrevocable. Lord, the sum and substance now, if I may conclude, is that, my Lord, a person, a lady, my Lord, executes a deed in favor of the daughter, executes, then cancels and executes a part, another part to the son, revokes that of the daughter, gives it to the daughter-in-law, then revokes that of the son and sells it to the son-in-law. This son-in-law files a suit for declaration. Declaration that I am the owner, permanent injunction restraining him. Defendant, the son, appears, says, I have knowledge of cancellation, says, I have knowledge that subsequent deed has been executed in favor of the son, does not file any counterclaim, loses in the first court, does not amend the written statement in the first appellate court. Lord, I make this submission for the first time today. Lord, Order 6, Rule 17, available even at appellate stage, not taken recourse to. Amendment of written statement with counter statement, not done. So no cross title set up. The issue framed by the court were with relation to whether I have a right, title, and interest over the property or not as to whether the annulment was illegal, void, inoperative. If that remains, then that is an annulment document, is a registered document, and it carries, my Lord, a presumption with regards to its validity. Even if I lose in this case, he does not gain anything because the cancellation still remains. My Lord would not decide the cancellation because the list is not before my Lord. My lord, this is, my lord, the sum and substance. My lord, the judgments relied upon by my learned friend, my lord, they inure more to my benefit than being of any assistance to my learned friend. My lord, I say that the second appeal, my lord, raises no substantial questions of law and should be dismissed upon imposition of exemplary costs. I am grateful to you, Lord. Sir. Huh? Yeah.
Mr. Paul, reply.
Kindly keeps it on Friday so that my lord, it can be concluded before the vacation, my lord. Thursday we have holiday, my lord, otherwise I would have.
Just after reopening.
We both have intended to conclude it before vacation.
Thank you, Lord.
Sir, एक तो difficult है यार.
If you
Let it,
হবে না শুক্রবার বললে পরে আফটার ভ্যাকেশন কালকে বললে পরে হয়তো একটা স্লোপ আছে
let it be on 10th. 10th,
Very well.
on the day of reopening.
I have no difficulty except for the fact that we would be unnecessarily troubling your lordship to remember something which is not worth remembering.
It has to be remembered until and unless judgment is passed.
No substantial question of law unnecessarily we are troubling your lordship. They should be dismissed.
Without hearing my reply.
And in the meantime, written notes be prepared.
As a lordship, please.
Those be furnished on 10th.
My lord.
The learned counsel representing the respondent. Respondent. Further commences the submission and submits at length. Concludes the same. Let the matter appear on 10th of June.
But 10th is, we are reopening on 10th. We do not know what type of situation would be in the list. This is going to take some time. Just the next day, 11th.
11th, my lord, I'll be out of station, my lord. Only for that day. And my lord can keep it on 12th. There's no issue.
In this situation, let it be on 10th. If it is not taken up, then on 12th. 10th.
আচ্ছা I am grateful to my lord, deeply obliged.
No, no.
Grateful, madam. Very good.
Acha.